Hi, welcome to our Challenge and Change webinar series, where we're focusing on some of the workplace health and safety considerations as we continue to navigate the realities of living with a virus that is unfortunately showing little sign of disappearing in the near term. I'm Shelley Meadows, a partner with Navigation Consulting and Training.
And I'm Martin Franchi, the other founding partner at the firm.
As we're anticipating moving into phase 3 reopening, and some of you may already be there, we're continuing our transitioning to the new normal segment with a focus this time on work refusals. So as we transition back, it's important to ensure workplaces are putting policies and protocols in place in order to ensure it's safe for employees to return to work. Why does it matter? It's not only is health and safety a legal requirement, but also a moral obligation. So failure to put proper protocols and policies in place can end up in disruption of work, either through illness, absenteeism, having to shut down again, or you can have fines or penalties or other corrective orders being issued by the Ministry of Labour. So it's really important that we go about this the right way. So our learning objectives for today's session is to understand the 3 basic rights of workers, understand the process of work refusals under the Ontario Occupational Health and Safety Act, discuss work refusals in the context of transitioning back during a global pandemic, and also understand those foundational principles to help mitigate or avoid work refusals as we go back into the workplace. So we'll start with the basic right of workers. So foundational to the Health and Safety Act is the right to know, the right to participate, and the right to refuse unsafe work. And so when we're talking in the context of work refusals, we're dealing with an employee right, which is the last one, the right to refuse unsafe work. So Martin's going to take us through some of the criteria for a work refusal.
Right. So what we're talking about today is the actual work refusal process. So I wanted to look at it just from a general perspective. With any hazard, this is how it actually works in a workplace. But we will be sort of looking at how it sort of dovetails into the COVID situation that we're experiencing. But we're going to start with what is this work refusal thing that we're talking about. So in Section 43 of the Occupational Health and Safety Act, there is some criteria that stipulates a worker may refuse to do work where they have reason to believe that, as this first one is up, says, any equipment, machinery, device, or thing the worker is using to operate is likely to endanger them. The physical condition of the workplace is likely to endanger them. The workplace violence may be likely to endanger them. And then the last one sort of emulates the first one. Any equipment, machinery that they're using is in contravention of the Act or regulations. So probably we're all experiencing the second condition, the physical condition of the workplace. That's really, when you look at COVID and our current environment, that's what we're sort of talking about today when people are exercising the right to refuse work with regards to COVID. Just before we get there, there is something to note that there is an exception in the Act. There is Section 43, subsection 1 and 2 talks about the fact that certain industries, if the hazardous work is part of your job, you cannot exercise your right to refuse unsafe work. So it's called a limited right to refuse work. And it gives you some examples: police, firefighter, frontline workers, healthcare. They have a limited right to refuse because that is part of their job, or if the worker's refusal would directly endanger the life of safety of another person. The other thing to note, as Shelley will articulate right now.
So we've talked about the employee rights. This is now the employer side. So what's the requirement for the employer? They have a duty to take every precaution reasonable in the circumstances for the protection of a worker. So one of the things I should note before we sort of talk about the language is this is from the Ontario Occupational Health and Safety Act. If you're in a different jurisdiction, provincially, or you're federally regulated, the requirements may be slightly different. You probably have something that is equivalent, but we are focusing on the Ontario one. Keep in mind with this, the specific language, it's actually vague. So there is some subject to interpretation component to this, and that it's under the circumstances. So in the context of COVID, it's been a very evolving and fluid issue with lots of changes as we continue to learn more about the virus. So you will have seen guidance changes along the way. So those every precaution reasonable in the circumstances will change and vary as the circumstances change and we continue to learn more. So that is important to keep in mind as well.
Yeah, and a little while later we'll see a slide when we're talking about maybe some ideas of mitigation. But as Shelley sort of just pointed out, is the reasonable grounds can be not necessarily debated, but what I feel is reasonable as a worker might differ from what Shelley is as my employer, and she feels she's done enough, and I don't feel you've done as much as you need. So it comes down to, this is probably where this exercise my right to refuse unsafe work sort of starts with. But when we're looking at it, this is the part of the duties of employers to take a precaution reasonable. And one of the things to note is that the Minister of Labor likes to look at employers and say, even though the Act gives you the minimal amount of things that you need to do and regulations pertaining to your industry, they really like you to go above and beyond the minimum requirements of the Act and to look at standards and guidelines to demonstrate that you're taking a precaution reasonable. So we'll touch on that a little bit later. But
I think, Martin, as well, it's going to be unique to your own work environment.
Absolutely.
Yeah, that it'll vary based on your industry, your physical buildings, whatever it is. What's reasonable will vary and be very unique.
Absolutely, and that's why there's these ideas of standards and guidelines that are more specific applications of the law, the regulations for your specific industry, as opposed to just the government stipulating them. So we're going to look at the actual work refusal process. So how does it start? What is happening when it sort of takes place? Is, well, the worker is at their workstation doing something, and they all of a sudden have this gut feeling. They can be incorrect. This is something to note. They don't have to be right, but it starts with a gut feeling. They have a reason to believe, a couple slides ago, that they might be in danger. So they call over their supervisor, right? And their supervisor will come to see what's going on, right? As we report it to them. So the supervisor will start this investigation and trying to ascertain if there's an issue. And, you know, the first thing they're supposed to do is move the worker away from their workstation and have this little dialogue and try to figure out, is there anything we need to do? Can we rectify it? And we go forward from there. So at this point, the worker member of the committee, or your health and safety committee if you have one, or a health and safety representative, will join the three of you, because unless you've resolved the situation to the satisfaction of the worker when you're just having the conversation with the supervisor, if they didn't resolve it, we bring in the health and safety representative. And this investigation sort of is continuing. At this point, this is where the worker has to articulate a little bit clearer of why they feel that they're in danger. Again, they don't have to be correct, but they have to say more than, I just feel unsafe. They have to sort of give some rationale behind it. So the worker remains in a safe place, right? And, you know, we're having this dialogue, we're trying to figure it out, but we might not be able to come to a solution. Or the reality is that the worker doesn't feel that whatever solution that's been proposed or mitigation that's discussed isn't enough for them. So then we're going to look at calling the Minister of Labor and having a Minister of Labor inspector come and investigate.
But at this point, Martin, if they resolve it, then if they agree that it either doesn't rise to the level of being unsafe, or they investigate and they rectify it, then we stop here.
Absolutely.
You go to the next step only if the parties can't agree.
Right. Only if you can't agree and the worker feels that it hasn't been resolved. But as Shelley just mentioned, if they resolve it, off we go. We go back to work. Everything's fine.
So before you go forward, Martin, the other question that comes up a lot is, who has the onus? So is it the employee onus to prove that the workplace is unsafe, or does the employer have the onus to demonstrate that the workplace is safe?
Well, interesting enough, the Occupational Health and Safety Act is broken down into various sections, and there's a section on what employers' duties are, and 25 and 28 talks about what workers' responsibilities are. And when you go and look at the duties of employers, there's lots of things. They talk about creating a safe work environment, and the whole history of the act was created because it was giving workers a voice to articulate their concerns and also giving them the benefit of the doubt. So from that, there's some language that gives them a chance to start to articulate things like this work refusal. So it always gives them a voice. So the onus is really on the employer to demonstrate that the work environment is safe, as opposed to the worker, have to say that I am in danger of getting hurt because of this. I shouldn't have to prove that this is going to injure me. The employer should be proving that it's safe.
Which makes sense. Yeah, and that makes sense given that the employer actually ultimately controls the work environment.
Exactly. They buy the equipment that goes paying. They pay our salaries and our conditions of work. So that's what you're looking at.
Great.
So as we continue on this process, if it wasn't resolved after the investigation, we call the Minister of Labor, and a Minister of Labor inspector will come forthwith. They may show up, or they may do it over the phone or virtually. I mean, in our new COVID environment, it's probably happening quite often. And this happened quite a bit even prior to COVID because there's only so many inspectors in the province, and like the province is quite large. So it's not a guarantee that they will show up. They may do stuff over the phone like a conference call. But anyways, in our scenario that we're just talking about now, they will show up. Let's just assume that. So in the meantime, before they've shown up, the worker remains in a safe place. They can be given some alternate work, something of equal value. If the employer sort of gives you a toothbrush and say, here, go clean the grout in the bathroom, that they're being somewhat punitive, that's wrong. You don't want to do that. It's a reprisal. So you want to give them some alternate work to do. The other thing that can happen is that the employer can assign the work to another individual and call Jane over to take my job over, let's say. But the thing is, they have to articulate to Jane that I refuse work. This was the rationale. And then here, Jane, you have the ability to either do the work or refuse it if you feel that it's unsafe. So it's just, again, making sure that they're aware and they understand the circumstances of what's going on.
So,
yeah.
One of the questions that comes up, I don't know if you were done yet or not, sorry, but a lot of people ask the question, is there a specific investigation process that needs to be followed when you're doing this investigation step?
No, actually, the investigation process can be as informal or as formal as you like. I think that it happens a lot in a workplace organically where, someone puts up their hand and says, I'm having an issue with this, or I don't feel comfortable doing this. And a lot of times, which is what you always want to hear, is that the supervisor will walk over and go, oh my gosh, let's rectify this. Let's make it so it's safe for you and you feel comfortable, and off we go. And we've just done it in a very informal way. People probably don't even realize they're sort of exercising the work refusal process because it just sort of happens. But in this scenario, as we're sort of talking about, it can start that way and it can still end in a very informal environment. Or maybe you've set up, your workplace actually has a more formal process, some documents to fill out, or there's a protocol list or checklist to go through. Whatever it may be, you as the employer gets to decide how formal they want it to be, right? So that's something that you figure out. Maybe you get some instruction or some guidance from your health and safety committee to help you sort of formulate that. It all depends. It's also really good for record keeping. If you ever get a visit by the Ministry of Labor, they do want to see documentation and minutes of meetings and stuff like that. But it also can demonstrate that you're taking every precaution reasonable by, hey, we had the situation, we rectified it, we've changed policy, procedures, whatever, to sort of hope it wouldn't happen in going forward. That's what we're trying to be ultimately, is we're all trying to be proactive to try to take steps to mitigate any hazards. So coming back to this slide is that the inspector has shown up. They're going to try to ascertain if any of the criteria in section 43 was met, those 4 boxes we showed you just a few minutes ago. And if one of them they feel meets the criteria, then it would be a valid work refusal. The inspector would issue a report, probably have some orders that they've written, some corrective action would be given, and the worker will, doesn't have to go back to work until this stuff is done. If there was not enough, or if the inspector doesn't feel that none of the criteria was met, then it's not a valid work refusal, and the worker must return to work. If the worker still feels that it's a problem, they do have an appeal process in writing 30 days to the Ontario Labour Relations Board, the OLRB, that they can do this. But at the moment, they do have to go back to work. If they still refuse to do work, then they'd be deemed insubordinate, and whatever disciplinary action you may have might be put into place. So that's something to keep in mind. So that's sort of the process as it looks. And then there's the next slide, just again, sort of reiterating some of it, and Shelley's going to articulate on this stuff.
Yeah, so we tried to put together a slide that kind of encapsulates some of the key elements of the work refusal process. So you see the reasonable grounds. There really has to be reasonable grounds so that employee feels that there is something that is unsafe in the workplace. Work comes to a stop, pay continues. So just because you're going through this process doesn't mean you don't pay them. You do have to continue to pay them throughout the process because they are allowed to have that work refusal and the pay protection afforded under that. Martin touched on the duty to advise other workers. So if you ask another worker to step in to perform the work during that investigation process, you do have that duty to advise that other worker that work has been subject to a work refusal. So it's sort of an informed consent to do that work. And then the last part on the slide is no reprisals, and that is key. You have to understand that that is a protection afforded employees under the work refusal, that you cannot take that punitive action against them for exercising their right. So what does it mean? Oh, sorry, I thought on to the next one. What does it mean in the context of COVID-19 and what's been sort of the history? We have definitely seen work refusals on the increase. So the Ministry of Labour between January to June had 280 work refusals. To put that in context for you, work refusals spiked in mid-March with 83 in a single week. So just as we were sort of hitting that beginning time. And that was a significant increase from the January-February time when the province averaged less than 4 work refusals a week. So that gives you the kind of context about how much these work refusals have increased in the era of COVID-19. Out of the 280 for the stats we had, only one was found to meet the criteria of a valid work refusal. We understand it was a company called Berry Global, where an employee came to work after possible exposure to COVID-19, and another worker refused to work. Obviously, our understanding of the virus has evolved over time, but that's an example of something where you could see the Ministry of Labour might uphold a valid work refusal. So you want to keep that in mind. But the lion's share of the work refusals were obviously deemed to be invalid.
So, as we are all transitioning back to work, more and more parts of our environment are opening up and allowing workplaces to become operational again. So we're going to look at the fact that people are going to be coming back to work. So the question starts, it's a bit different from in beginning of the pandemic when the shutdown happened and everyone was asked to stay home. Not a lot of information was out there. We're learning about the virus, how to mitigate it. But now we're sort of talking about, we do have some better information. So we are opening up our businesses. So, you know, you can look at there's many criteria or many things that might concern people, but maybe the top two is like when you look at like a fear or anxiety about coming back to work, because I don't know if it's going to be safe. People might think I just don't want to go, and maybe just a generalized anxiety about it, or they maybe perceive that the fact that the employer isn't doing anything to protect them in their mind about what protocols or what things have they done to mitigate the exposure to the virus. The other one could be how I get to work. If I used to take public transit, let's say, and now I'm concerned about taking that because of exposure. Like, can they refuse work, you know, before we even get back to the workplace? And unfortunately, as this next slide sort of shows you, there's a couple key things to remember is that the language is written that you have to be at work to exercise your right to refuse unsafe work. So you can't do it before you even get to work. You can't sort of just have a generalized fear of just coming to work. That isn't the language as we see it now, just doesn't sort of cover that. It can be a bit frustrating because people might have valid concerns. They might not think that the employer has done anything or taking it seriously, but the reality is you have to show up to work, and then you can exercise the work refusal, which starts the process, you know, potentially getting the Minister of Labour involved and maybe having some orders written. But that's the employer or employee, I should say, the worker being at work and sort of doing this and exercising it once they're there.
And so if you reach an impasse, it may be deemed a job abandonment if an individual refuses to come in. At this point, you would be reaching out to your HR professionals or your legal counsel if you're hitting that impasse. Hopefully you don't get to that point in time. Empathy and communication can go a long way to resolving issues. I mean, I think it's important we as owners of the business ask whether it's really necessary for that individual to come in, or is there an alternate solution that might be possible. There's other challenges also that we face with this particular situation. So Martin touched on transit. So transit to and from the office is not the employer's responsibility. However, maybe there's ways that you can address it. So could you consider reimbursing parking or an Uber or a taxi because they're more comfortable, say, in a car with windows down and masks on than they are getting on the TTC, as an example. So that would be one thing. Another challenge we face are caregivers. Either the individual is at risk themselves, or they're a caregiver of a child or elder care where there's an underlying health condition that might put them at more risk than the average person, that might be causing them that extra fear or anxiety dealing with it. We really are in uncharted territory here. Mental health issues can arise, that sort of fear and anxiety. If it rises to the level that it's considered to be a disability, it is possible that there might be an issue, and it could be failure to accommodate could be challenged under our human rights complaint. That goes beyond the scope, obviously, of what we're sort of specifically addressing today, but we want you to know that beyond just the work refusal under the Occupational Health and Safety Act, there may be other reasons that you need to accommodate, or that you may experience a worker sort of refusing work that would be valid other than under the Occupational Health and Safety Act. It's also possible in this uncharted territory that Ministry of Labour position may change. I think it's unlikely given the numbers and given the knowledge that we have learned over the time. So we have lots of guidance on it. But again, things can be subject to change. So you just want to be aware of that. And so if you have these challenges and you do reach that impasse, again, it's reach out to legal counsel, but hopefully you don't get there.
So some question is probably coming up. It's like, so how do we actually mitigate work refusals? How do we create an environment that will make workers feel safe to come into work? So there's a few things that you can look at, policies and procedures that you create, following public health guidelines, involving employees, the workers, like in a conversation, and communication and training. I just wanted to sort of talk about, Shelley sort of brought into it or touched on that public health guidelines or protocols or any information that we've had today, because the situation is so fluid and we are learning more and more every day, a protocol you put into place today might not actually be enough to mitigate it tomorrow or next week. It's completely frustrating, I understand this. But it's like you have to sort of be on top of, as new information emerges, what else can we do, or what can we do that comes to mind to mitigate the exposure to the COVID virus, right? And how do we change things? Because maybe we realize that even though 2 meters is a suggested distance, maybe in the future it'll be 3 meters. Maybe we'll need more, perhaps less will be okay. The point is that things are always changing. And
I think, Martin, good point. There's a lot of very specific industry guidelines that are out there and accessible. So it's good to sort of seek those out. On the policies and protocols, it's always best practice. Well, it's not best practice. It's usually a requirement. Have them in writing. Make sure that you do have them in writing. The investigation is a best practice that you document that in writing. Make sure policies and procedures are properly communicated and sufficient training is done. So in any change management initiative, communication is key, and it has to be ongoing. COVID really is no different. It's a major change management initiative that we just haven't had the choice to undertake. So be prepared as well to pivot with new information and a changing landscape if we see a resurgence in the virus. The other best practice that we have in the slide, the involved employees. So whether you strike a task force or you undertake surveys, understanding what will make your employees feel safe is important and can really increase the buy-in if they're part of the solution. So that's why you really want to involve them. Needs and preferences for returning to work also may vary. So some people can't wait to get back to the workplace and others will be quite hesitant. So again, to the extent that you actually can accommodate that and work with your employees on that, to consider their preferences or allay their fears with things that they need to make them feel safe, will be an underpinning of success for you. Because at the end of the day, happy workers means a healthy and productive workplace.
Awesome. So even though we didn't talk about specifics of what you can do, we did address this in a previous webinar that you can get off our website that talks about or gives some ideas or some concepts of what you might be able to do in your workplace that would address the COVID-19 exposure and some of the fears. So this is just a slide, and Shelley will sort of articulate a little bit more about it.
Yeah, so it really was just a springboard for ideas, and we did get into specifics within each of these categories of things that you might want to consider. As well, at the bottom, it's those foundational principles of success. So being agile, adaptable, creative, out-of-the-box thinking, the policies, protocols, and training, always key. And in red, I always reiterate it time and time again, is that communication and support is really the cornerstone of success of any kind of change management structure. So look that up on our website if that would be of help to you, and hopefully it does. If anyone has any questions as a result of the webinar today, feel free to reach out with us. We're going to be putting up our contact information, and we just wanted to thank you for tuning in. And if there's other topics, if there's questions out of today, or you had other topics that you would find helpful for us to cover in the future around workplace health and safety, please reach out and let us know. We would be happy to help if you need bench strength, reviewing or drafting policies, and would like us to assist in your training as you go back. We'd be happy to do that, and so feel free to reach out to us on that.
Yeah, it was so nice to have you listen to us and visit us today. So hopefully you stay safe, and perhaps we'll see you at our next webinar topic.